kind of position. I've got Kelly Phelps on the line, senior lecturer at UCT. And Kelly, thank you very much indeed for joining us at short notice.
That's my pleasure. Thanks for having me.
Kelly, explain to us, because the scorn poured on the judge was instantaneous and maybe without sufficient thought?
I think completely without sufficient thought. I think it was also, unfortunately, very predictable, considering the tone with which this case has been reported from the beginning. And that has been in an air of really utter misinformation throughout. It's been partly complicated by the fact that the trial was being interpreted by people who didn't understand the law and therefore didn't always understand what they were actually seeing playing out before them. And it was also very unfortunately and disgracefully for the legal community in South Africa, complicated by the fact that people who actually did not have a speciality in criminal law pegged their names to this trial in order to get publicity and gave commentary on this trial that, in a sense, legitimized the commentary because it was coming from a legal quarter, but in fact was not informed commentary. And it set up, in a sense, two different dialogues and trials at the same time. So there was the trial happening in the media,
yes,
and then there was also the trial happening in the courtroom. And in terms of the trial that was happening in the courtroom, this outcome was not only a predictable outcome, but it is arguably, in terms of current South African law, criminal law, the correct outcome. And it is also the reason why all similar cases to this one generally get prosecuted as culpable homicide. They are not actually prosecuted as murder. And I suspect that even in this case, if an offer of culpable homicide had been made from the state from the beginning,
yes,
we probably would have avoided the trial. We wouldn't have spent millions of rands of state resources on this trial. We wouldn't have subjected her family and friends to the secondary trauma of having to relive the events in the public trial. And in that sense, if there has been a travesty, that is where the travesty has occurred. And I think the manner in which the legal community here spoke out so instantly after that verdict, before even applying their minds to the reasoning that this very learned woman, very experienced woman, had applied in this case, is really a disservice to the profession and a disservice to the public.
It seems as if people are beginning to backtrack or beginning possibly to have read the judgment more thoughtfully and beginning to agree with exactly what you're saying.
Yes, and that really is a lawyerly approach, and which is why it's so shocking that people spoke out so vociferously in the immediate aftermath. You know, one always accepts in law that the person who has had the most access to all of the evidence, as well as being immersed in all of the relevant legal rules, is the judge and the assessors. And I should say as well that the assessors have become completely invisible in this debate in the aftermath. This woman did not apply her mind to the facts by herself. She actually reached a verdict that was the unanimous finding of the court. So the two assessors agreed with her finding. And one should always wait and first try and engage with the reasoning of the judge before assuming that just because you don't understand it, she must be wrong. And I think a massive disservice has been done to her. And she has had an amazing career, not just in law, but prior to law in journalism, where she was a central person reporting on the Soweto uprisings, in fact. And her entire professional legacy is one of brilliance and courage. And the fact that people just automatically assumed, A, she must be wrong, and B, that she, who deals with the criminal law, and dolus eventualis is a central concept in criminal law, she deals with it on a daily basis in her career, that she must not understand it is quite frankly absurd.
Where do you think it actually went wrong at the time of that judgment? Was it you expect members of the public like myself? I mean, I have no knowledge of the law really, and so I need things to be explained to me. So, do you think it was in the stage where people were explaining it, possibly on Channel 199, which had very, very high ratings because it was very absorbing to watch?
It was very absorbing to watch, and I have to say I didn't always think, though, it was very informative to watch in terms of accuracy. And I do think a lot of misinformation occurred there. Certain commentators were not actually South African lawyers, and therefore giving their impression on South African law having been based in a completely different legal system. And other South African lawyers were not criminal law specialists. And the criminal law is a very different system of law. It operates under very different principles and in a very different environment to the civil law system. Mm. So those nuances that get lost along the way in interpreting sets up an expectation in the public, certainly, that when that expectation is then not met, there is a sense of outrage that a miscarriage of justice has occurred. But I think that to a large extent, the state themselves have been complicit in that, because they have been very free to share their views with the media all the way back from bail. And unfortunately, one can actually trail through media reports that cite state sources where the media report was completely misinformed. And the state will have known that they were construing the context evidence that they were leaking. And that has also led to, in a sense, a massive build of misperception within the public. And it set up a convenient situation for them that when they lost the case, it was not the state who lost the case, but it was the judge who messed up the verdict. And it was precisely that self-fulfilling prophecy that played out in the aftermath. And I do think this is a case around which there are such strong passions, and people feel so passionately either way on the divide about it, both in public and in practice, that when you then mix the media into that and all of this attention and hype that has been solely focused on this case for such an extended period now, I think it's quite easy to get lost in that hype and get carried away. And I unfortunately think it was that sort of momentum at play in the aftermath of this judgment.
Did it not begin, though, in your opinion, with Hilton Botha? It seemed to me within hours of being in the house, wearing the wrong clothes, probably touching the wrong things, who knows? But it did seem to be chaotic in terms of the early part of the police investigation. But it was he who announced very, very confidently that it was premeditated murder.
Absolutely, and he also, in fact, leaked certain pieces of evidence into the media at the time of the bail hearing, which once they were subjected to scrutiny in court, ended up being completely different from the context in which he'd construed them. So, for example, we had these reports that Pistorius had killed her in a testosterone-fueled rage and that illegal hypodermic needles had been found next to his bed. That ended up, after testing, being a perfectly legal herbal supplement that he had permission to use. There were also stories leaked that he had killed Steenkamp by beating her to a bloody pulp with a cricket bat, whereas it became very clear very soon into bail that the cricket bat was simply used to open the door and it had blood on it from having been on the floor. Now, you know, these are things that he would have known already. They would have known that when they were on the crime scene, that, as you say, was handled in such a poor manner. And that, in a sense, it set a ball rolling in terms of an expectation that the state had a strong case, that I feel like they felt they needed to follow through with afterwards. There was just no backtracking once they'd started on that trajectory. But it really has done a disservice because it's entered a lot of white noise into the public domain, that people believe certain things are facts that simply aren't true. And the kind of impact that must have on her family in terms of preventing proper closure and a feeling that you've got the truth is really very difficult to even estimate.
Mm-hmm. Well, I have it on reasonable authority that Reeva's mother is bringing out a book, that it's been organised, there's a cover already being done. So it seems as if it continues with the sense of grievance, which you can understand. Your daughter is dead. You can understand that, but it appears there's no closure. Just a final question for you after a very enlightening conversation. TV, the television coverage, I think it has been massively helpful for many people to see how a court actually works and everything like that. But do you think that there was some grandstanding? Do you think it's done the job that it was intended to do?
I think there was a massive amount of grandstanding. And I think people have seen the way this trial works, but that isn't necessarily the way every trial works. I think it's very good that people have become interested in the criminal justice process and trying to understand it. I'm not sure that the grandstanding around this trial has brought them much closer to that understanding, and I do think that that's a missed opportunity. It's certainly been useful for me in the classroom as an illustration of seeing how principles play out in practice, but it's been quite an unrealistic trial for the public to follow.
Kelly, I'm sure I'm going to be chatting to you again. Thank you very much indeed for chatting to us. Kelly Phelps.
Thank you for having me.
Thank you. Kelly Phelps, Senior Lecturer, UCT, Department of Public Law, and one of the first lawyers to stand out and said Judge Masipa's judgment